Our esteemed Acae has joined us. So thank you for your. The president may now like to take it over.
Yeah. Perhaps there is a network issues with RD sir. He is not visible to us.
Yeah, Anup.
Yeah.
Hello. Hello. Hello.
Yes, sir. We could able to hear you, sir.
There was a sound, but after that I'm not being able to hear.
Video.
There is a network issue, sir. So video is not coming, only audio is coming.
Plus, sir is also not visible, I think.
Vivek, RD sir is not.
RD sir has joined, but he is not visible to us.
Log off and log in.
Yes, now sir is visible. Now it is perfect, sir. You are visible. Welcome, sir. Welcome to ACE. Sir, your audio is not coming.
It's not audible. I'm not being.
You're perfectly audible. Sir. You're perfectly audible.
You're perfectly audible, sir. Sir, you could able to hear us? Sir, very good evening to you, sir. Whether you could able to hear us?
Corporate advisors and
sir, whether you could able to hear us? Sir, good evening, sir.
এটা তো অ্যালাউ করছে না গভর্নমেন্টের মেশিনে অ্যালাউ এটাতে ভালোই হয় শুরুতে আওয়াজ ছিল
স্যার গুড ইভিনিং স্যার
ওরা কত দিয়ে বলবেন 5
বন্ধ করতে স্যার
বুঝতে পারি
হ্যাঁ বুঝুন না
কোন বান প্লিজ give me a moment.
Sir, Rao sir, please bear with us. We are actually awaiting our RD sir to join. Rao sir,
Yes,
please
sir.
bear.
Welcome. No problem.
Let me introduce myself. I am Anup Sanghai, sir. I am president of this organization, ACE. We have Mr. Mohit Buteria, CA Mohit Buteria. He is the chairman of Company Law Committee in ACE. Mr. Vivek Agarwal is the senior vice president. Mr. Sumantro Guha, he is our executive committee member.
Sir, you can hear us. We can hear you. Ajit sir, we can hear you. Can you hear us?
Actually, now I can get your voice, but I'm not getting the other voices.
No, RD sir, am I audible to you? I am Anup Sanghai, sir. Very good evening and warm member.
I'm telling you, Abhi, you are audible to me.
Okay.
Now you're audible to me, but otherwise some voices are so simple, I'm not being able to get. But you are audible to me.
Okay.
Anup sir, please.
Yes. With your permission, can we start the program, sir?
Yes, please.
Yeah. Very good evening, friends. I am Anup Sanghai, President of ACAE. A very warm welcome to each one of you at this forum of Association of Corporate Advisors and Executives. On behalf of ACAE and on my own personal behalf, I welcome our chief guest for today's session, Sri Devasis Bandhopadhyay Sir, Regional Director, Eastern Region, Ministry of Corporate Affairs, and Dr. P.V.S. Jagan Mohan Rao, Past President ICSI, and immediate past president SAFA at ACAE, and also welcome all our delegates for today's session on NIDHI companies. Just to introduce, Association of Corporate Advisors and Executives is one of the oldest professional bodies in Kolkata, which has been established in the year 1960. It has completed 60th years on 26th of August last year. We have 1300 plus membership of the association, which includes, the members includes chartered accountants, company secretaries, CMA and advocates, industrialists, entrepreneurs, businessmen having interest in the areas like accounting, taxation, legal, auditing and businesses, etc. The ET Bengal Corporate Awards in association with Times of India is our signature event being held annually. In past, we have eminent speakers in our forum, Bharat Ratna Sri Pranab Mukherjee sir, Sachin Pilot sir, Dr. Amit Mitra, late Jayaprakash Narayan, statesmen like Sri Somnath Chatterjee, respective industries like Sri B.K. Birla, Y.C. Deveswar, B.M. Khaitan, Sri R.S. Agarwal ji of Imami, Sanjeev Goenka, Harshvardhan Nevatia, T.V. Mohandas Pai, and many others has already graced our platform, and they have spoken on in length at our various events. Friends, let me just introduce our today's topic. It is I'll just briefly, because I do not know much about NIDHI companies, but today's topic is very interesting. NIDHI is basically a Hindi word which means finance or funding company. NIDHI means a company which has been incorporated exclusively with the object of developing the habit of thrift and reserve funds amongst its members, receiving deposits and lending to its members only for their mutual benefit and welfare. Subject to correction, we have learned speakers with us. We have chief guest RDs Sri Devasis Bandhopadhyay sir with us. With this opening remarks, now I hand over the proceedings to our company law committee chairman CA Mohit Ji Buteria for formal introduction of our chief guest today. Over to Mohit Ji Buteria.
Thank you, Anup ji. It is a great pride and honor to introduce Regional Director Sir before this August audience. RD Sir is a BCom Honors, Cost Accountant, Company Secretary and LLB. He is also a member of the Insurance Institute of India. After having served 11 years in corporates in various capacities in secretarial, legal and financial discipline, he joined Indian Law Corporate Service through UPSC around 20 years ago. Since then, he has served as the Deputy Director Inspection, Deputy ROC in West Bengal, then Registrar of Companies West Bengal, Bihar, Jharkhand, Northeast States, Delhi and Haryana. Sir has also served as Official Liquidator of Patna, Ranchi and Guwahati High Court. He served in the Ministry of Corporate Affairs in the position of Director Inspection and Investigation, Regional Director of Northeastern Region, Northern Region, and then presently, Sir is the Regional Director of Eastern Region. Sir, we are very privileged to have you with us, sir. Thank you so much, sir, for accepting invitation of ACE. And
Thank you very
we request all members present to welcome sir with a applause. So, may I now request Anupji sir will start the
Yes, sir will have his.
Sir, please start your deliberation.
Thank you, Buteria ji. At the outset, I express my deep gratitude to the Association of Corporate Advisors and Executives for organizing this much needed program. You have really exhibited your sensitiveness to the social cause and organized such a meaningful program today. And Mr. Sanghai, Buteria ji, Mr. Rao and other dignitaries present, and all the esteemed participants in today's evening program. Thanks to all of you. Now, the topic today is NIDHI company, which is capturing our attention in the ministry for quite some time. Now, the NIDHI companies are basically meant for bona fide purposes to develop saving habit among the people. But the facility is being misused by many people with ulterior motives. They are mostly opening the NIDHI companies in mofussil, suburban and rural locations and taking advantage of the lack of awareness in those locations are raising monies from the inhabitants of those locations. It is possible that after raising sizable sums, many of these companies would ultimately decamp, leaving the hapless investors behind. This is which is causing a lot of concern for us. Now, the main sensitive area is the period of 1 year from the incorporation of a NIDHI company, when the newly formed NIDHI is operating to have at least 200 members, to have a net own fund of 10 lakh rupees or more, to have a ratio of net own fund to deposits of maximum 1:20, and to have unencumbered term deposit of at least 10% of the outstanding deposits. These are the 4 criteria to be satisfied by a NIDHI company. For that, 1 year time is granted from the date of incorporation. After that, they have to apply to central government for obtaining the necessary notification as a NIDHI company. But this is the area where they are remaining virtually unregulated. Earlier, Reserve Bank of India was having a regulatory oversight on NIDHI companies during this intervening period. But in November 2007, this exercise was withdrawn by Reserve Bank of India. Since then, this 1 year period remains a bit open. Now, it is imperative to sensitize the general public about such companies, NIDHI companies, so that they refrain from investing their hard-earned money in non-compliant NIDHI companies, and also to ensure that the investors are not duped through fraudulent activities of non-compliant NIDHI companies. I have already sensitized the Registrar of Companies of Eastern region in the 4 states, West Bengal, Odisha, Bihar, and Jharkhand, for keeping close watch on the delinquent NIDHI companies and to take them to task in the case of defaults, including physical inspection of their offices, etc. I have also written to the chief secretaries and the DG police of all these 4 states in the region and requested them to kindly instruct their officers to keep vigil on the NIDHI in public interest. Now, at the same time, I earnestly request the chartered accountants who are auditors of these NIDHI companies to be a bit vigilant on the activities of these NIDHIs. And in view of the above facts and circumstances, I am requesting support of the professional members and the local chapters of the Institute of Chartered Accountants and the esteemed study circles and bodies like you to keep a close watch on the activities of the NIDHI companies operating within their ambit and to spread awareness among the residents of those areas where these NIDHI companies are operating. The strong initiative may please be taken to sensitize the management of NIDHI companies on the complying of the rules and provisions of the Act and regarding the NIDHI companies, so as to enable them to act diligently in true letter and spirit of the provisions of the law. So another, a storm of Ponzi scheme does not again have an advent in the state of the Eastern region. It's a perfect handholding is required between the government and the professional fraternity. Thank you very much.
Thank you very much, sir. Thank you. Many thanks for your keynote address to the professional fraternity at large. The ACA corporate advisors will definitely take care of the inputs being given by you, and we will also sensitize our members about the NIDHI companies. Sir, you would like to stay with us for the entire session?
I will be for another half an hour. I am here.
Okay, sir. Okay.
Uske baad I have to have another meeting.
No, we wanted like the formal vote of thanks part. Then we'll offer it after half an hour. That will be okay, sir. Yeah.
No, I don't want to disrupt the meeting in between. Kindly carry on. I am with you always.
So Vivek, our senior vice president, may I request you kindly give a formal vote of thanks to our guest speaker, chief guest Sri RD sir. Vivek, over to you.
Thank you, Anup Kumar Sanghai, President ACAE, for giving me this opportunity to give formal vote of thanks to none other than our chief guest, Sri Adi Bandopadhyay ji. Friends, we are very fortunate to have him over here at a shorter notice, because last week only we went and met him. And I, Vivek Agarwal, the Senior VP of ACA, on behalf of ACA and on my own behalf, extend a very hearty vote of thanks to sir from bottom of our heart. The world is hit by COVID-19 pandemic, and we actually don't know when it will end. But we know one thing, that we should be always there, hand on hand with government authorities. And we are thankful to Adi sir for sharing his thoughts, insights, and experience on areas of needy companies to be sensitized, because we don't want any further chit fund scam or anything in which the public who loses their money at large are the daily wage earners and the poor class. We confirm that we as a professional body are hand on hand with government authority, and we will always be there with the department and Adisar and MCA for that matter. Thank you once again, sir, for this accepting our invite and being a chief guest on this important topic of Nidhi Company today. Thanks a lot, sir.
Thank you, Agarwal.
Vivek, memento to the sir.
Yeah. On behalf of ACA, I would also like to present a memento in this digital world, a digital memento for sir.
Thank you very much. Thank you.
Thank you, sir. Over to President Anup Kumar Sanghai ji.
Thanks, Vivek. Thanks for vote of thanks to sir. May I now request our learned speaker, Dr. P.V.S. Jagan Mohan Rao sir, to talk on the topic Nidhi companies. The audience, the delegates are eagerly awaiting to hear it out. What exactly is the Nidhi companies? So straight away over to Dr. P.V.S. Jagan Mohan Rao sir. We have a PPT also of the sir. May I request Priyank, could you please share the PPT? Yes, Mohit ji.
We have to introduce, sir.
Yes. Okay. Mohit ji, kindly introduce the sir.
Yeah. It is a great privilege to introduce Jagan Mohan Rao, sir. He's a MCOM, LLB, FCS, FCMA. He has done doctorate in communication, journalism, PhD in capital market, MA in astrology, MA in Sanskrit. Sir is the past president of the Institute of Company Secretaries of India, former Central Council member of the Institute of Cost Accountants of India. He was the member of NACAS, Government of India, and member of Accounting Standards Boards of SEBI. Sir has a long list of achievements to his credit. I can go on reading. Sir has published a lot of articles on climate change, environment, global warming, articles in the Chartered Secretary, Management Accountant, Chartered Accountant Journal, Financial Express, and other publications. Sir has also a list of books to his credit. Book on general meeting, company secretary, corporate governance, Bhagavad Gita, company secretary, corporate governance, Sundarkand, and climate change. So these are some qualities which we found rarely in somebody. Sir, with these words, I would request Mohan Rao sir to kindly start his deliberation.
We welcome you, sir, at ACA.
Yeah. Good evening to you all. Vakratunda Mahakaya Surekoti Samaprabha Nirvignam Kurume Deva Sarvakaryeshu Sarvada Vasudeva Sutam Devam Kamsachanura Mardanam Devaki Paramanandam Krishnam Vande Jagadgurum. So Sri Anup Kumar ji, President of the association, and our very highly distinguished Sri D. Bandopadhyay sir, Regional Director, Eastern Region, the Ministry of Corporate Affairs, who is also member of our institute, the Institute of Company Secretaries of India, and also member of the Institute of Cost Accountants of India. It is a great occasion to see our Regional Director present here. It means the ministry is present here. Thank you very much, sir, from my side as a speaker, and also as a former president of the ICSI, and also former council member of the Institute of Cost Accountants of India. And Shri Vivek Agarwal ji, Senior Vice President, and Mohit ji, Vice President, and Butaria ji, and Mamata ji, and Sunil Binani ji, my distinguished friends in the Institute of Company Secretaries, and Shubham Jain ji, and Shri Sumantra Guha ji, and all of you present here. It gives me great pleasure to share my knowledge or ignorance on the NIDHIs. Let us see how do we spend. I have some slides, and I have addressed some time back in the Institute of Cost Accountants of India in our eastern region on the same subject, where our Honorable Regional Director sir was present also there. And it is nice that our Regional Director is present also today. And thank you very much, sir, Bandopadhyay sir, for giving us this great opportunity. Thank you very much. And then coming to, as our Regional Director sir has said, this is basically a mutual benefit kind of a thing, in the sense that this is NIDHI. NIDHI is an organization basically for mutual benefits, and it is for the benefits of only members. That we should keep in always mind. That is, its services are available only to its members, not outsiders. So that is the reason why they are called mutual benefit society. And whenever I say that, since our distinguished member has read my biodata and mentioned that I have done my MA Sanskrit, I am tempted to quote one sloka from the Bhagavad Gita, which I am remembering now, which is relevant to our subject today. That is, Devan Bhavayata Nena, Te Devan Bhavayantaha, Parasparam Bhavayantaha, Param Sreyam Avapsyasi. It goes like this: Devan Bhavayata Nena, Te Devan Bhavayantavaha, Parasparam Bhavayantaha, Param Sreyam Avapsyasi. Param Sreyam Avapsyasi, Parasparam Bhavayantaha. If we remember this sloka, as our regional director was mentioning, we should not see another Ponzi companies. That will not happen. So these are all the messages that we have. This is the sloka in Bhagavad Gita, where Lord Krishna has given this sloka to the Arjuna and to all of us through the great warrior Arjuna. So the meaning of this sloka is Devan Bhavayantavaha. It means that, he is suggesting us, whether he is commanding us to always pray Devas, and in turn they will give all benefits that you need. So when we do yajna, these benefits are taken by the Devas. They give in turn, for example, 1 point to share. They give rains. From the rains we get food, we eat, and then we live. So this is mutual help from people to people. So Devas, and then all of us, the living beings. So Parasparam Bhavayantaha, it means Parasparam Bhavayantaha means mutually helping to each other. So we need to help each other, as Krishna in himself has enshrined in the Bhagavad Gita. Unless we help each other, there won't be anything. In the last line, it is said that Parasparam Bhavayantaha, Paramam Sreyam Avapsasi. Paramam Sreyam, the utmost good will happen to all of us. So this is one thing which I can share with you. And then coming to the NIDHI, as I think somebody mentioned, this NIDHI is a Hindi word. NIDHI is a Sanskrit word actually. Of course, many Sanskrit words are there in Hindi. So you see, if you recall, there is a maybe all of you from the eastern region in Calcutta, you might have not heard about, maybe all of you might have heard about also. There is one very great poet centuries ago called Tyagaraja. Only 2-3 centuries back, I think. Tyagaraja, or maybe a little more than that. Tyagaraja is a poet who has written thousands of poems on Rama. He is very highly famous in Telugu. He has written in Telugu, and then he has composed, and then he has sung the songs, created the music. So when he has done that, he said that in Telugu, I am not going to tell you the song, but only to connect to the concept of Nidhi. He said that Nidhi, do you want Nidhi or Ram Namam? So you need money or Ram Namam. See, Nidhi means it is your assets altogether is called Nidhi. You hold that Nidhi, treasure. You can say treasure. Do you need the treasure of material things, or do you need the treasure of treasure that you can get from chanting the name of Rama? There are, I think, more than thousands of slokas are there. If you go to Chennai, you can find the T Nagar. There is a very famous area called T Nagar, where I know that all film actors used to stay there, including the N.T. Rama Rao, who has been the Chief Minister of Andhra Pradesh and then a national leader during his time. So NIDHI is that. It is a treasure. So now coming to the NIDHI companies, can I have the slides now? So at the outset, I would like to, before starting the slides, I would like to express my sincere thanks to my colleague in the Institute of Company Secretaries, Mamata Binani ji, for giving me this great opportunity. She has been a very young, dynamic president of our institute. She has brought a lot of colors to our institute. And I always wish all the best to her and Sumit, all the best to both of you. God bless both of you all. Then coming to this topic, yeah, next slide. Yeah, NIDHI. What is NIDHI? As per as a NIDHI, we have seen what our scriptures say. But NIDHI, as per our Companies Act and the rules made, there is only one section in the Companies Act 406, and the rules made in 2014, and the rules have been, some of the rules have been amended in 2019. So NIDHI means a company which has been incorporated as a NIDHI. So you can incorporate a company as a NIDHI with the object of cultivating the habit of thrift and savings among its members. So as I have already told you, it is only for its members. So it can be, a NIDHI can be incorporated only to forward further the objects of only members of the NIDHI company among its members, receiving deposits from and lending to its members only for their mutual benefit. This is this definition. This section, this is section 1 of section 406. So this section itself gives us complete idea of what a NIDHI company is. So it says that receiving deposits, see, when it's a finance company, it's a finance company, but it is not an NBFC again. It is not a bank. It is a finance company, but not NBFC and not a banking company as per those legislations. But in any case, it's a finance company because it renders only financial services. But it is a limited kind of a thing, only to and among its own members. So their mutual benefit. And you see, again, they see whenever you dissect, see, this is how I like to read company law. A beautiful company law is a very beautiful legislation any day. So whenever you each word in the first section of in the first subsection of any section in the Companies Act, if you take up that and by heart and then dissect it and then divide it into parts and then try to understand, you can get a full grasp of the section. Benefit which complies with the rules made by the central government, mutual benefits. And you know that the transactions cannot be for the benefit of anybody else, only for mutual benefit among them only. If I borrow for somebody else's benefit, probably that will not, that coming under the definition of mutual benefits in this 406 subsection 1. And then we have to comply. What is the regulatory body? We have to comply with the rules made by the central government. Section empowers us to start a NIDHI company for these objects. But at the same time, who will regulate us? The rules, 2014, NIDHI rules 2014, brought in by the central government, amended from time to time. As I told you, in 2019 also, there were certain amendments. I am including all those amendments in my presentation. Regulation of such class of companies. Okay, next. NIDHI's provision relating to NIDHI's and its application. As I told you, this is the section 406. In this section, NIDHI or mutual benefit society means a company which the central government may by notification in the official gazette declare to be a NIDHI or mutual benefit society as the case may be. So the point is that you can incorporate a company, and we will see as it goes by. A NIDHI company only a public limited company. This is another important point we have to note. If you are, as a practitioner, if you are trying to incorporate a company for your clients, it can be only a public limited company, cannot be another type of company. So whenever you have NIDHI companies, you can incorporate the company and then apply for the declaration by the central government regional director, and then that you can get the company recognized as NIDHI or mutual fund society, whatever as the case may be. Next. The central government may by notification in the official gazette direct that any of the provisions of this act specified in the notification shall not apply to any NIDHI or mutual fund society, or shall apply to any NIDHI or mutual fund society with such exceptions, modifications and adaptations as may be specified in the notification. So central government is empowered in the legislation. Legislation empowers the central government to declare a company as a NIDHI company, and also central government is empowered to say that certain class of companies are these provisions will not be applicable to. And then if they maybe with some kind of modifications or adaptations, if they say that it will be applicable through their notification, yes, to that extent it will be applicable. Next. A copy of every notification proposed to be issued under subsection 2 shall be laid in the draft before each House of Parliament while it is in session for a total period of 30 days. And if both the houses agree in disapproving the issue of notification, or both houses agree in making any modifications in the notification shall not be issued, or as the case may be, shall be issued only in such modification form as may be agreed upon by both the houses. So the point is that you have to place before any modifications, the central government will have to make a notification and then place before the Parliament. And then you see that whenever you place before the Parliament, if any one house disapproves that, that will not be true. But if there are any modifications, both the houses will have to approve that, and subject to that those modifications and operations, and then the notification will be approved by the Parliament. Then next. In reckoning any such period of 30 days, as is referred to in subsection 3, no account shall be taken of any period during which the House referred to in subsection 3 is prorogued or adjourned for more than 4 consecutive days. This is very clear. In case the House is closed for 4 years, that will not be taken for the counting of 30 days. Otherwise, it can be taken. That is the interpretation of this thing. You also can read it later. The copies of every notification under this section shall, as soon as may be after it has been issued, be laid before each house of the Parliament. So it has to be laid before the Parliament as early as possible. Next. Membership and share capital. A NIDHI shall be a public company, I have mentioned to you, with NIDHI Limited as part of the name. So whenever we have any private limited company, we need to say that it is a private limited company. Excepting in case of a that section 8 company, we have to have the limited at the end of the company. Any company incorporated in the Companies Act, we need to have limited. And then in case of public limited company limited, private, anyway, specially we have to mention private limited. So now in the case of NIDHI Limited, you have to mention NIDHI Limited. In any case, it is only public limited company. Minimum paid up share capital of 5 lakhs. So this provision is there in case of a NIDHI companies. Minimum capital is prescribed as 5 lakh rupees. NIDHIs cannot issue preference shares. This is another important provision which you have to keep in mind when you are giving consultancy to the NIDHI companies. Preference shares are not permitted in the case of NIDHI companies. Only equity shares are permitted, and no other securities also. It is only equity shares. Only individuals can become members. Again, very important thing is that it is only individuals who can become members. Say, that as we are aware, for incorporating a private limited company, 2 members. For incorporating a public limited company, 7 members. These 7 or 2, as the case may be, can include incorporated companies also. Like, ITC, Hindustan Lever, Godrej, Reliance also can promote and incorporate. They can be promoters of limited company. But in case of NIDHI companies, you cannot. It is only individuals who can become members of the NIDHI companies. A NIDHI shall not admit a body corporate as a member. It is not only at the time of incorporation, even at a later point of time also, any body corporate. Body corporate is obviously a little wider definition. So any body corporate also cannot be a member of a NIDHI company. A trust also cannot become a member in NIDHI. See, not only incorporated companies or body corporate, but it cannot be a trust a trust at whatever may be the trust in India or abroad, a trust also cannot become member of NIDHI company. Whatever may be the trust for, but still it cannot be member of the NIDHI company. A minor shall not be admitted as member of the NIDHI. You see, minor cannot be, we are aware of the discussion on the minor. I am not going in detail about that. A minor cannot be member of the NIDHI company, but deposits may be accepted in the name of the minor if they are made by the natural or legal guardian who is a member of the NIDHI. So you can accept deposits from a minor when a member of the NIDHI is the guardian for a legal guardian for natural or legal guardian for that NIDHI company. NIDHI, sorry, for that minor. So minor cannot become a member. Minor can become a deposit holder provided he is represented by a member as a natural guardian or a legal guardian. Next. Rule 5.1. You see, some of the rules I have made as it is, I have taken here for the purpose of clarity. Rule 5, subsection, sub-rule 1, every NIDHI shall within a period of 1 year from the date of incorporation ensure that. So you have incorporated a company, public limited company, and within 1 year you have to incorporate. This is what our Honorable Regional Director was mentioning. It is not less than 200 members. So it should have at least 200 members and net own funds of 10 lakhs or more. Net own funds. This is the net own funds to 10 lakhs or more. Unencumbered term deposits of not less than 10% of the outstanding deposits. What do you mean by this? Unencumbered term deposits of not less than 10% of the outstanding deposits. Whatever may be the outstanding deposits in your NIDHI company, take 10%, take 10% of that outstanding deposits and then put it in a unencumbered term deposits. It should be unencumbered is one point, and again term deposits. Where do you keep the term deposits? In a nationalized bank, and cooperative banks you cannot put it again, if I remember correct. You can put it in the post office deposits. So as permitted in as it is permitted, you can keep only in that kind of approved deposits 10% of your outstanding deposits as unencumbered term deposits. The NIDHI company has to put it in the form of term deposits. Ratio of net owned funds to the deposits not more than 20. So it is not more than 20 times. Even the 20 times itself is a very higher amount of net owned funds to deposits, not more than 1:20. If the ARD above is not complied with, so in case you see, in case ARD, A is that 200 members, D is ratio 1:20. If both the sub rules are not complied with, then regional director may consider and pass order for extension in 30 days. See that we have to complete, you have to ensure the compliance of this within a period of 1 year, as it is in subsection 1 heading. So it has to be complied within 1 year. You have to ensure the compliance. As an auditor, you see that as an auditor, when you are a chartered accountant, company secretary, cost accountant, you can carry on the audit of these things. And when you are carrying on the audit, wherever that in the course of time we will see that wherever you as a professional is entitled to audit or check, you need to ensure these provisions. These are all the very important provisions we should keep in mind. We should keep in our mind to have a checklist like. So whenever you think in terms of that, in case you are unable to comply within 1 year, these provisions, you can apply to the regional director, and the regional director will provide the extension up to 1 year. He can provide up to 12 months, 1 year, maybe 1 month, 2 months, as it may be in his own discretion. Regional director can permit, but he will do it within 30 days of making your application. So if you make an application today, within 30 days, he will take a call and then provide the extension up to 1 year, whatever may be the period. This is and then the date of receipt of the application. So the application form for the purpose of making this extension, for the purpose of extension, when you are not complying with A and D, you need to do it in NDH2 form. Also is prescribed in the rules. then within 90 days of incorporation, file a return of statutory compliance in form number NDH1. So within 90 days of incorporation, file a return of statutory compliance in form number NDH1. So this can be certified by CSCMA CA. You check up that, and then you have to ensure the compliance within 90 days. 90 days you have to ensure the compliance and file the return with the registrar of companies. Next. And I think I've forgotten to place that. You see, the NIDHI companies, large number of NIDHI companies. I think even 80% are, about or more than that. 80%, we can say 80% of NIDHI companies are from the South India. And then whenever you think in terms of, again, in South India, you have again very, very large number of NIDHI companies only in Tamil Nadu. And some companies in Kerala, Karnataka, Andhra Pradesh, Telangana, this part, and then some companies in other parts of the country. So this is how it is. If you want to read any case on the NIDHI companies, you say hello to your company secretary, cost accountant, or chartered accountant colleague in these parts of the thing. To share with you, last time when I was giving this presentation in the CMA Institute, somebody has heard from Coimbatore and has called me, and then of course he wanted the presentation. I've given the presentation, and he had some doubts, and then he was actually incorporating a NIDHI company. He has got an assignment. So this is how that the beautiful services being rendered by this great association will be useful to the whole world. This is what Binani Madam has told. Then she has, when I asked her that can we give it to somebody who's interested, she said that you can do it. So this is how we spread the knowledge. So again, my presentation also you can circulate to all the people, whomever they want. You can circulate to cost accountants, chartered accountants, company secretaries, lawyers, or any industrialist anywhere in the country or the world. You can send it. I don't like to have anything that I was sharing with Mamta Binani Madam some time ago in the evening. You see that that knowledge is to share, knowledge is not to store. So even in my books where I have written very clearly, you can use freely whatever I have written in the books. Naturally, that for academic purposes, if it is for your self-development, you can always use this. So all my ratings, all my presentations are completely usable, freely usable. I don't believe in that kind of a right to have not to use that. So freely usable, you can circulate to anybody, whomever you want, whoever needs that. And if there are any corrections and mistakes, please correct them, and then also intimate to me. I will also correct myself. So the failure to comply with the sub rule 1, rule 5, NIDHI shall not accept deposits. So we have seen the rule in the previous slide. If these provisions in that rule are not complied with, NIDHI shall not accept deposits. This is a serious provision. So that you have to comply. You have to comply within 1 year, or as may be extended by the Honorable Regional Director. And after that, if you comply with that, fine. If you don't comply, you cannot accept deposits. So this is also one thing where we have to ensure as professionals that these things are complied with. NIDHI shall not accept deposits from the commencement of second financial year. The period is provided with that. So whenever you are not complying after 1 year, but it is after second financial year till it complies. So the point is that you can again apply for the that condonation or whatever extension, and after compliance you can accept again. You can carry on your activities as a NIDHI company as provided. So provisions contained in sub rule 1 and gets itself declared under subsection 1 of section 406 besides being liable for consequences. So please remember here another important point as professionals we should note is subsection 1 of section 406 is very important. I have already read it for the benefit of all of you. And not only you need to ensure the compliance, but in case of delay, all the other consequences, whatever may have occurred before you comply, all the other consequences you will have to bear them. So you have to educate as a professional your clients on this particular issue. Then next, NIDHI rules 2014. We are going specifics. I've told you in nutshell, and then in as covering points I have covered. You see, very, very important points of NIDHI companies I have covered. I do like that because whenever you attend any webinar, maybe for important work you may leave. So within this 10-20 minutes, you get the gist of what NIDHI companies that we have done with now. We are done with now. And then now the specific rules we will go into and see. NIDHI rules 2014 in force from 1/4/2014. They apply to whom do they apply? They apply to every company which has been declared as a NIDHI or mutual benefit society under 620A of Companies Act 1956. So NIDHI companies incorporated under earlier legislation also are under NIDHI rules 2014. And second point is, every company functioning on the lines of NIDHI or mutual benefit society, but has either not applied for or and has been applied for and is waiting for notification to be NIDHI or mutual benefit society under section 620 of the Companies Act 1956. So what do you understand from this third paragraph here? So you can apply for, you see, ultimately when it is a NIDHI company, it is a NIDHI company or mutual benefit society only when the government notifies that. It is not that after incorporation you will be called as NIDHI company. It has to be notified by the ministry. And then there are two things that if you bisect this third paragraph. So if you have started the NIDHI company and you are not applied for that, you are carrying on the activity, you are not applied for that. That is one category. But you have applied for that and you are yet to get the notification done by the ministry. So there are one thing is that you are not applied. Second thing is that you have already applied and waiting for the notification by the government. And the third thing is that you are notified. These are the three categories you should keep in mind. Then this all the three types of categories, this NIDHI rules 2014 are applicable. And then every company incorporated as a NIDHI pursuant to the provisions of section 406 of the Act. Obviously, after the Act has come, it has got its own section 406, and NIDHI companies are now notified under section 406. So those companies also, this set of rules will be applicable. And every company declared as NIDHI or mutual fund society under section 406. We have understood this. Next. Yeah, you see that as it is in the case of a banking company, you see what is the definition of a banking company? To the extent I remember, the definition of banking company is borrowing for the purpose of lending. That is a simple definition of a banking, borrowing for the purpose of lending. So here also it is borrowing for the purpose of lending. So some of the these issues that we find in banking business or NBFC business, we find also here. Though NBFC rules are not applicable, banking rules are not applicable, but they are defined in the section 406 and the rules within themselves, they are defined. So in any finance business, we have doubtful debts, we have loss of assets and loss assets, and we have net owned funds, and we have non-performing assets. All these kinds of categories are there in every kind of a business that relates to the finance. And obviously they are there also in the case of NIDHI companies. Now, doubtful assets. What is the doubtful asset? A borrowed asset non-performing for 2 to 3 years. So a borrowed asset, see some borrowal has occurred in the NIDHI company and then not performing well. That is non-performance for 2 to 3 years. That we have to categorize into doubtful assets. Then there are prudential norms also. I don't know whether we can go detail into prudential norms. There is a separate section for the prudential norms. I will give you some highlights of that. So prudential norms are to be complied with for all these kinds of category of assets. Loss assets. What is a loss asset? A borrowed asset non-performing beyond 3 years. So in the first case is doubtful asset. If it is 2 to 3 years not performing, that is called doubtful asset. But beyond 3 years, it will get into the status of loss asset. All these things have to be provisioned as per the prudential norms prescribed in the rules. Loss asset, a borrowed asset non-performing beyond 3 years. Net owned funds, paid up capital. You see that we have seen that net owned funds for the ratio purposes and all. So net owned funds, what do you mean by net owned funds? Paid up capital and free reserves, less accumulated losses and intangibles. You see this point is very well known to us. It is known to us. The same thing comes over here also. Paid up capital and free reserves minus accumulated losses and the intangible assets. Then non-performing asset. What is a non-performing asset? Non-performing asset means a borrowed account in respect of which interest income, installment of loan remained unrealized for 12 months. So it is, we have seen that default asset, loss asset, net owned funds, and then basically doubtful asset, loss asset, and then you have non-performing asset means interest income, installment of loan by borrowers. Borrowers have not paid. Your own members they are, but still they have not paid on the sums they have borrowed, either interest or the installment due as per the agreement. So unrealized for 12 months. If we process 12 months, it will be treated as non-performing asset. So you need to make certain special different provisioning for non-performing assets also. Next. Standard asset means the asset in respect of which no default is. You see that non-standard asset, we have seen that. What is the standard asset then? Standard asset means the asset in respect of which no default in repayment of principal or payment of interest has occurred or perceived. You see, the beauty is another word they have used here, perceived. So there is no default in respect of the principal and the interest, but also there is no perception. You are not perceiving, okay, that this is likely to, maybe, those kinds of things are also not there. It is not even perceived. Completely clear and healthy assets. That is called standard asset. And which has neither shown signs. You see, again, in the as I told you, each section we need to dissect and then take out important points and read it so that we never forget about that. Which has neither shown signs of any problem relating to payment of principal sum. Again, so they say that neither shown signs of any problem. And then where is it written? Signs of any problem. So we have to, as a professional, understand, and then we have to conceive those kinds of things. What is a sign of any problem? And then, you know, that maybe I don't know, there may be some standard by the CS Institute or CA Institute or CMA Institute. We need some standards to interpret these kinds of things. Then only we are safe. Otherwise, no, we will not be able to interpret properly, and then we may be questioned later. If the standards are there, they will guide us. So now, you know, that I don't know if there are any standards. If there are no standards, maybe we can look forward to such kind of standards. Whenever the institutes feel that they are necessary, they will bring it. The principal sum or interest does not carry more than normal risk attached to the business. Again, no, what they say normal risk. What is the normal risk? See, why I discuss a little deep into these kinds of provisions is, as our honorable regional director was mentioning, that, you know, that we should not lead into any kind of end like Ponzi schemes that we have seen earlier. So if that should not happen, these definitions, these words must be very carefully observed by the professionals, and they have to ensure that these things are complied with if there are any problems. So carry on the normal risk. What is the normal risk? Risk attached to business. That business, we have to find out what is the normal risk. Maybe if we can have a standard, maybe in some other standards also, in accounting standards or secretarial standards, which I have not gone through in the recent past, if there is any definition or understanding of the normal risk, we need to ensure that. And of course, as a professional, we need to ensure our care. It is not that, you know, it is not that normal care, but it is a professional care. Informed care we need to observe and then ensure that these things are complied with. Substandard assets means a borrowed account which is non-performing asset. So substandard asset, another classification has come here which is not there in the previous slide. Substandard means standard asset we have seen in this first paragraph. Second paragraph, substandard is below the standard, means a borrowed account which is a non-performing asset. And we know what is a non-performing asset in our previous slide. Then reschedulement or renegotiation or rephasement of the loan installment or interest payment can change only after satisfactory performance for at least 12 months. The point is that there may be a consideration by the NIDHI company that some of or wherever it is required, the loans are renegotiated or rephasement, you know, that payment later kind of a thing, rephasement kind of a thing is provided, rephasement kind of a thing is provided. Next, no?
Sir, one moment, sir.
ठीक है. So this is what we need to keep in mind, that in case of any rephasement or in case of a rephasement or renegotiation or reschedule, you have rescheduled the loan repayment structure. In that case, unless and until 12 months go through without any hassle, only after that you can consider them as a satisfactory kind of a thing. Till then, it will be treated as substandard or whatever, wherever definition it falls within. Substandard, you know, that non-performing, all kinds of things. 12 months period is necessary to say that I have become a good boy. Then only it will be taken into perfect account. Next. Declaration of NIDHIs. Central government on receipt of application in form NDH4. We have seen what is NDH4. NDH4 is an application along with the fees from a public company. The public company also we have noted shall notify the company as NIDHI in the official gazette. See that if any company is there in as a public limited company incorporated, it cannot be called as NIDHI company, you know, like any other public limited company. Is a full-fledged public limited company after the company is incorporated, when you receive the certificate of incorporation. But here in the case of NIDHI company, government has to notify that in the official gazette of the country. Then after NIDHI amendment rules 2019, the NIDHI 4 shall be filed within 60 days from the date of expiry of 1 year from the date of incorporation. This is the time period that has been given in the 2019 rules. They have made it very clear to comply and enforce. The period up to which the regional director is extended. We have seen these 2 points there, you know, that 1 year from the date of incorporation. We have already referred to that earlier. And regional director has got power to extend, and then if it is extended within that time. If the rule is not complied with, the company will not be allowed to file form number SH7. What is SH7? Alteration of share capital. For alteration of share capital, if you are not permitted to file SH7, you cannot increase the capital. The shareholders members cannot come there. So it is a problem. So business is affected to that extent. Then you are also not entitled, if you don't comply with this provision of filing NIDHI 4, you will also not be entitled to file PAS3. PAS3, all of us are aware, that is return of allotment. So you cannot make an allotment and then you cannot file the return of allotment. Then your business is restricted to that extent. So ensure the compliance, file it, and then go for the filing of these 2 forms, SH7 and PAS3. Next. Rule 6. General instructions or prohibitions. No NIDHI shall carry on the business of chit fund, hire purchase finance, lease finance, insurance, or acquisition of securities issued by any body corporate. So please remember, this is a very, very important provision. And look for some clients. I know all the cases already done in Tamil Nadu or Kerala. You will find a lot of cases there. These things are very much, you know, that they are very interesting actually. So carry on the way. You cannot carry on. You see, as a NIDHI company, this is also one of the doubts. One of my, you know, that friends has asked me. He's from some other place, not Coimbatore, but in South. So the point is that, you know, he didn't tell me where it is the company. Otherwise, I would have mentioned that. See, that thing is that you cannot, as a NIDHI company. So as a NIDHI company, you cannot carry on other finance related business. Other related business like chit fund, hire purchase finance or leasing finance. So if you have a NIDHI company, you cannot render loans for hire purchase and leasing business. And you cannot carry on the insurance business as well. And acquisition of securities issued by any body corporate. So you cannot carry on the business of business in securities. So buying and selling of securities issued by any other body corporate, you cannot carry on. Only your business lending for the purpose of borrowing only among the members of the particular NIDHI company, that's all. Not even NIDHI company members of other NIDHI companies. It's only your members, your among the members of your NIDHI. Issue preference shares or debentures or other debt instruments. So NIDHI company cannot issue preference shares, that we have already seen that. NIDHI company also cannot issue any debentures. I also mentioned that. Any other debt instrument also. So you cannot raise money from the public or anybody, even from your own members. You cannot take any debt instruments. You cannot borrow money from your own people and give debt instruments. So this is also very, very important kind of a provision here. We should keep in mind when we have NIDHI clients. We cannot, the NIDHI company cannot issue preference shares. NIDHI company cannot go for debentures and raise money. NIDHI company cannot raise money in the form of any other debt instrument also. Open current account with its members. You see, the point is that, a NIDHI company as a finance company can open recurring deposit account with the members. Members can open recurring deposit. Members can open recurring deposit accounts with the NIDHI company where they are members, and they also can open savings bank account, but they cannot open current account. Current account with the NIDHI company is not permitted. Company cannot entertain that. Then acquire another company or control of board of directors of another company, or enter into arrangement of change of its
Yes, I have one question.
Yeah. Please.
So sorry to interrupt you, sir. So I am Shubham Jain. So my question is, like, what is the rationale behind? I can totally understand, like, NIDHI companies cannot accept deposit from other than the members, right? But what is the rationale? Why they can't issue debt instrument to its members? What is the reasoning behind that? Any preference share? Why they can't issue any preference share to its members? Outsiders, I can understand. They are not allowed to accept any sort of money from outsiders. But why not from their members?
Yeah, probably. I can only say probably. The reason might be, when you go beyond a particular one source. So your management is a small company, isn't it? You see, we see as it goes by, we see you cannot open a branch beyond your district. You can have only 3 branches. And after beyond three branches, beyond your own district, if you are going within the state, please remember the activities of NIDHI companies are only within the state. And then you need to take the permission of regional director when you are doing many of these things. So if you go into preference shares or debt instruments, whether it is through your members or somebody else, it may lead into certain other complications. Members may borrow money from somebody and then invest here, and then that kind of business interest will develop. It may spill over into larger kind of activities where we have risk like Ponzi instruments. So
I will request all the questions to be taken at last as the flow gets stopped. So I request the members kindly wait for the end. Sir is there for us with us till 7 o'clock. So let's complete his presentation and deliberation. Then we can take all the questions. Thanks a lot. Continue.
Okay, I think as far as this question is concerned, I have answered. The point is that, it may be the intention that these benefit societies or NIDHIs are meant for a small business and only for the purpose of benefit among the members. And then though it is from the members, you take the preference shares or the debt instruments, but that will get into, or it may be a temptation. There may be a temptation to go in for a business kind of an activity. And then when you deal only with your members, and then, a small kind of an activity allowed, so control will be more better, and financial health of the company can be monitored better. Probably that is the reason. Yes. Then open current account, not this resolution. Okay. Then your company, the NIDHI company, cannot enter into any agreement. You cannot have control over the other board of directors. You see that in case of a normal business and normal companies, that you may have, any agreement among the members through articles of association or special resolution or ordinary resolution. These are permitted. So articles of association is basically the regulation for the companies. So in case of these companies, you cannot have that kind of an arrangement to have control of other companies through the board of directors or board of directors of those companies. So again, the point is same thing. Confine only to what you are doing. Confine to small business. Look after only your members and be happy. That's all. Mutual benefit. That's all. And again, that change of its management, unless it has passed a special resolution, there is a change of management of other companies. Certain permissions are provided in case all the members approve as in the form of special resolution. See that all these other kinds of things, special resolution, section 149, 152, that 164 in the Companies Act. I'm not going into detail. All of you are aware of section 164, section 149, section 152. All the sections in the Companies Act, they apply to the NIDHI companies also, unless they say that these sections are not provided. Here I would like to say that there is a separate exemptions. Central government under the powers to exempt certain companies, central government has exempted certain provisions of the Companies Act, not applicable to the NIDHI companies. That I am not going in detail. I have incorporated in the slides, but if they are not incorporated, please read it later. What do you need to read it later? Exemptions to NIDHI companies. There is a separate section in that, notification. You will find any standard book. Exemptions to the NIDHI companies. That point in detail I am not discussing. They are not discussing, but there are certain company sections, provisions which are not applicable to NIDHI companies. Subject to that, my point here is, if you're a chartered accountant, cost accountant, company secretary, you are handling the audit or issue incorporation and management of these NIDHI companies. Keep in mind, all the sections of Companies Act are applicable, excepting those provisions which are exempted for NIDHI companies specifically by the ministry. That is the point which I wanted to make. So that special resolution pass it, and then even if you pass a special resolution for the purpose of any arrangement of change of its management, unless you pass a resolution, not only resolution, but you also have to take the previous approval of the regional director. These are the two important points in this slide. Okay, next. No NIDHI shall carry on any business other than the borrowing or lending to its own name, You can read it as in its own name, excepting providing locker facilities to its members, where the income from such locker business does not exceed 20% of its gross income at any time during the financial year. So again, as I told you, you need to dissect every section and every provision, every paragraph, and understand what are the points that you get if you dissect this particular paragraph, second paragraph here. So you cannot carry on the business excepting business between the members, among the members, mutual benefit only. We have seen that noted already. But at the same time, you cannot carry on, again, if it is mutual purpose also, you cannot carry on the hire purchase, leasing, so on and so forth. Those are not permitted. All these things are excluded. Be very clear. To the extent I can understand, I can tell you, this is a very restricted kind of a business, ultimately to ensure the financial strength of the company, so that the gullible investors are not faced with problems, and these don't get into the Ponzi kind of investments and then failures as it goes by. So they are restricting the rules, regulations, provisions are restricting you, the NIDHI companies, to carry on only specified permitted business. That's all. But here in this slide, what we see is, you can provide locker facilities to your members. You can charge them for the facilities that you have provided. But at the same time, whatever you have provided, you can charge for that, but the income that you gain from that cannot be more than 20% of your gross income of that financial year. During the financial year, whatever you have, within that, up to 20%, you can charge your members for providing the locker facilities. Is an income to you. Only I think, in the whole history of this entire section 406 and the rules made thereunder in 2014, I find only this business is permitted apart from the borrowing and lending among the members. accept deposits from or lend to any person other than its members, that we have already noted. Next. No NIDHI shall pledge any of its assets lodged by its members as security. You see, another beautiful thing that we have here. You see, if you read from this, our distinguished friend has asked the question at that point of time, why not raising debentures from our own members of the NIDHI company? If you apply that here, you cannot pledge any of the assets of the, see that the members of the company, when they borrow money, am I clear? When members of the NIDHI, when they borrow monies from the NIDHI company, definitely they provide some security, jewel, gold, or whatever. So whenever they are providing the security, the property, even though that immovable property can be provided as security. So whenever these kinds of property is provided, you cannot use that security for any other purpose. Suppose, say for example, if a debenture issue is there, that assets are provided as security, but the one person's security, one person's assets or group of persons' assets are provided as security for the entire debenture. And you may question me why it can be unsecured debentures also. Then again, you are going to the risky kind of a thing. So I think, this point clears our earlier question also. Pledge, NIDHI company can pledge any of the assets lodged by its members, either gold and jewelry or the immovable property. You cannot use. Take the security and ensure the repayment. If the repayment is not coming, you can utilize only for that purpose and not to spread it to other people or other businesses. Take deposits from or lend money to only, this is beautiful. Take deposits from no companies. The point is that no NIDHI company can deposit or take any money from any body corporate. So body corporates cannot be accepted as as lenders or lendees. Enter into any partnership or arrangement, it's borrowing or lending activities. So as a NIDHI company, I cannot enter into partnership with another company for carrying of NIDHI business of my NIDHI company. Again, it is restricting. Entire thing is restricted and then brought to only specified activity. Then issue or cause to be issued any advertisement in any form for soliciting deposits. You can take deposits only in any case from the members only, but in any case you cannot go for providing any advertisements to collect the deposits. Pay any brokerage. See that no company can pay any brokerage, cannot give any incentive for mobilizing deposits from members or for deployment of funds for granting loans. So if anybody is helping you to place loans among the members, you cannot pay him any commission or brokerage. And you also cannot get the commission or brokerage when you are helping the NIDHI company to encourage members to deposit. So again, this is also, see, the whole set of regulations are restricting and ensuring compliance only very small activity of lending, borrowing between the members and among the members. Next. Rule 7, share capital and allotment. Can issue fully paid up equity shares of ₹10. So we have already seen that it is only equity shares. And again, see that in our companies, you can go for a face value of ₹5 or ₹1, ₹2, any denomination, you can go for that. Long time before in Companies Act, we had only 10 rupees or 100 rupees when I was doing my CS or something like that. So now you can go for any denomination, face value. Then now in case of a NIDHI company, you cannot go for any other face value excepting it is only ₹10 because the rule says it is only 10. Then no service charge on issue of shares, that we have noted. Each deposit holder, minimum 10 equity shares or shares equivalent to 100 rupees. This is another important point. Each deposit holder, even when you are making a deposit into the company for getting some income on that, interest income on deposits you want to get, so you are placing the deposit in the NIDHI company. Then you need to be a member. Obviously, you need to be a member. and then you need to have at least 10 equity shares or 100 rupees. 100 rupees anyway, it is the case, 10 into 10, 100. Then savings account and recurring account holder shall hold at least one equity share of rupees 10. So the savings account and recurring, you see, this also we have seen that you cannot have a recurring deposit or saving deposits with the NIDHI company unless you are a member. So at least you need to take one share. Okay. So what is the thing? What is the difference between the third paragraph and the next paragraph? If you are making deposits in the company, NIDHI company, you need to take 10 shares into 100 rupees or whatever. 10 shares into 10 rupees, 100 rupees or whatever. Or if you are not depositing money into the company, but you are taking only savings account and recurring account you are opening, then you need not have to go for 10, but at least one share you need to have. See, when you are actually handling these kinds of NIDHI companies, you will come across the necessity of understanding all these small provisions also. As I told you, my friend, he's a company secretary from Coimbatore, and he has discussed with me all these points, and then he is explaining to his client. They have given a presentation to his client. So this is where it will help you out. Then next. Membership. Body, corporate or trust cannot be a member. We have already noted that. Unless as permitted in these rules, minimum number is 200. This also we have seen that. Minor cannot become member. Yes, this also. You see, I have explained to you in the beginning itself, as I told you that you should know the minimum kind of things. So I told you in the beginning to get you as a brief executive summary or something like that. Same points have come here. They are provided in Rule 8. Next. Net owned funds. Every NIDHI shall maintain net owned funds not less than 10 lakh rupees or such higher sum as the central government may specify. This is another important thing. You can say even a prudential norm or whatever. Every NIDHI shall maintain net owned funds not less than 10 lakh rupees or such higher sum as the central government may specify. You must have at least, you must be solvent at least to that extent. That is probably the intention. Next. Rule 10 branches. I was slightly mentioning some time earlier. A NIDHI may open branches only if it has earned net profits after tax continuously during the preceding 3 financial years. So you cannot go for any branch unless and until you are an established NIDHI and you have continuous profits, record of earning profits for continuous 3 years, 3 financial years. So you need to have an establishment of 3 years continuous profit, then you can go for opening of a branch. Then up to 3 branches within the district. So as I was mentioning to you, you can open only up to 3 branches in the district, but more than 3 branches or beyond the district, regional director permission is required. So you need to approach the regional director for his permission when you want to open more than 3 branches in the same district, or you want to go beyond the jurisdiction of the state, the district. So the base prima facie business is meant only within the district with 1 branch, but you can open up to 3 branches in the same district without going to the regional director. But if you want to go beyond your district and also you want to go beyond 3 branches, then you need to obtain the permission from the regional director, prior permission. Then outside the state, not permitted. See, this is the beautiful point here. Outside state, if a NIDHI company is incorporated in the West Bengal, so you need to have the operations of that or branches of that business of that NIDHI only within the state of West Bengal. Then closure of the branch. You can close the branch. You can close any branch, but you have to publish an advertisement and file intimation with the registrar in 30 days of closure. So it seems that no prior permission is required here. You can close the branch within 30 days, intimate to the registrar of companies. That will suffice. Next. Acceptance of deposit by NIDHIs. A NIDHI shall, this is a rule number 11. I am going rule by rule, even if I have mentioned earlier, but I am going by rule by rule. A NIDHI shall not accept deposits exceeding 20 times of its net owned funds as per its last audited financial statement. We have noted that, no, 1:20. So a NIDHI shall not accept deposits exceeding 20 times of its net owned funds as per its last audited financial statement. As on what date? Last audited financial statement. Rule 11. Next. Rule 12, application form for deposit. This is a beautiful thing. Please read it. I have not mentioned many of the things in this, but because of I don't, it will be too boring if I mention all those things in the slides. But I can share with you if you so want. We have some time here. You see, every company. Let me pick up that particular thing. Yes, here. So now rule 12, application form for deposit is prescribed. You need to have all the details like what we have in the company's deposits. So here also it is required to have this information. Every application, though it is from your own members, but still you need to have all these kinds of information. Every application form for placing a deposit, go back, no? Every application form for placing a deposit with a NIDHI shall contain the following particulars, namely name of the NIDHI, date of incorporation, date of declaration or notification as NIDHI, the business carried on, and details of branches, and some other particulars if you want to have, if I want to share with you. Net profits of NIDHI before and after making provisions for tax. See that you have to give the details of the net profits. Brief particulars about the management of the NIDHI company, name, address, and occupation of the directors, including DIN. No, you have to give the details. You see in the deposit application form, you have to give the basic things like NIDHI name and all, but also information about the brief particulars about the directors of the company, and then net profits, directors' names, and then their DIN also. Net profits, net profits of the NIDHI before and after making provisions for tax for the preceding 3 years. So next, the preceding 3 financial years financial information also required to be provided in the application form for the deposits. Dividend declared by the NIDHI during the preceding 3 financial years. Not only just financial statement and profit and loss account and balance sheet or whatever, but you also need to give the details of the dividends, mode of repayment of deposit. How do you want to ensure the repayment? How do you want me to, how do you as a NIDHI company repay my deposit back to me? Maturity period of the deposit, interest payable on the deposit, what interest you are going to make? Can NIDHI company make any interest, any amount of interest to the members? That we will see later. The rate of interest payable, and if you prematurely withdraw any deposit, suppose you have put it for 3 years, and then you have withdrawn after 1 year, what is the penalty that you have to pay? Then again, terms and conditions subject to which deposit may be accepted. What are the other terms and conditions subject to which you intend to accept as a NIDHI company deposits from me as a member? And then you also need to give a summary of the financials of the company in the provided format. The format is provided in rule 12. So you need to provide in that rule what are all the things that they are provided for our quick reference: net owned funds, deposits accepted, deposits repaid, deposits claimed but remaining unpaid. These are all very important information as a depositor. I would like to know what are the things. Net owned funds. What is net owned? Because even for 1:20, we have to. I have to ensure that whether I am putting in a company where compliances are in place. Then what are all the amounts of deposits you have already accepted as a NIDHI company, and then what are the amounts that you have already repaid, and deposits claimed. Some people have claimed but you have not repaid. From that only I can understand the solvency. Then loans disbursed, how much amount the NIDHI company has disbursed so far, and what is the amount disbursed to the members against each security, like against immobile property, how much loan you have disbursed, how much loan you have disbursed against the deposits made by the members, and how much loans you have sanctioned to the sanctioned and disbursed to the members against the security provided in the form of gold and jewelry. And then what is the provision before the tax, provision after the tax, profit before the tax, and then provision of tax, both. And the profit after tax, dividend. The application form shall also contain the following statements, namely, see, there are a lot of statements which I am not going through because of the time. I will give you some other important things, but read whenever you want to, whenever you have any client in respect of NIDHI companies, even in Tamil Nadu, Kerala, you can have the clients. There is no bar in that. So you can read it. So, because why I want to take few minutes on that discussing on the application form is, this is a very, very important form. If this form is not properly complied with, you are not giving a information what is required for the investor, for the member to invest in your deposits as an informed investor. He must be informed of all the things that are happening in the company. Those are provided beautifully by the Ministry of Corporate Affairs in this form. Rule 12A, Rule 12A is really a beautiful kind of a thing. You can write good article on this if somebody is interested. So these kinds of things, these kinds of information is required even for the company deposits. But in case of NIDHI companies, they are more specifically required as per the Rule 12, as I understand. Next, we will get into the next slide. Deposits. This is another very important slide. We should spend a little time, maybe 1 or 2 minutes. Minimum period of 6 months and maximum period of 60 months. So what is in the case of company deposits that you refer there? I am not going into discussion of those things now. So minimum period in case of NIDHI companies is 6 months and maximum period of 60 months. 6 to 60 months. Means that 5 years, 12 into 5, 60 months. Recurring deposits, 12 months to 6 months. Recurring deposits, you cannot accept less than 12 months. Savings account, the maximum balance in a savings deposit account at any given time qualifying for interest shall not exceed 1 lakh. Beauty. You see, if you are opening a savings account subject to he being a shareholder and member of the company, NIDHI company, you can open a savings account for your member and you can have an amount up to 1 lakh rupees in that savings account of your member open with your NIDHI company. But you can have more than 1 lakh, but you will not pay interest beyond 1 lakh, whatever he deposits with you. So if somebody comes to you, you should tell them, if he is depositing 2 lakhs, sir, you will get only on 1 lakh the interest, not on 2 lakhs. That is probably the understanding of this section. Savings account, the maximum balance in a savings deposit account at any given time qualifying for interest shall not exceed 1 lakh. Then how much rate of interest you can pay on the savings bank account? You can pay 2% more than the savings account that any national bank pays. So if any nationalized bank pays any X amount, say 3% or 4%, you can pay the 3% or 4% plus 2% in your NIDHI company. So fixed deposit interest not more than NBFC's interest. So in case of savings bank, you need to note that in case of savings bank, the interest is 2%. You can go up to 2%. See, it is not more than 2%. Not more than 2% of the savings bank account in any nationalized bank. But in case of fixed deposits, it is different. You can refer to the NBFC's interest, and then you can not more than that interest. What is that NBFC interest? RBI guidelines provide from time to time. What is the interest that can be paid by the NBFCs? So you can take the same interest rate and then provide the same interest for your fixed deposit holders of your NIDHI company. Next. Unencumbered time deposits. I think I have already told you with this unencumbered time deposits, not less than 10% of the deposits outstanding. So whatever may be the deposits outstanding, take 10% of that and deposit with a nationalized bank or post office savings bank as is provided. I think, as I was telling you, cooperative banks are not permitted, I think. So go through that provision and then deposit not less than 10% of the deposits outstanding. Temporary withdrawal with the permission of the regional director. This is another important provision in case of NIDHI companies. You see, as a NIDHI company, you can You have already 10% up to 10% of the outstanding deposits with the nationalized bank, for example. You can withdraw and make it less than 10% for any temporary and urgent purpose with the permission of the regional director. Regional director can permit you. So whenever when you are an auditor as a chartered accountant or CS or CMA, you need to keep in mind that you have also ensured a check, and it means that you have checked whether RD permission has been received for withdrawal of the amount from the deposits that you kept with the nationalized bank or so. Permission is granted by the regional director, then you have done that. See what happens, why I am stressing a little on this provision is, if any company has not maintained, or it is not in a position to maintain 10% of the deposits, 10% of the outstanding deposits in the that prescribed bank or account, then what happens? The company's health is not good. Company's health is not good. It may be a sign of some kind of downfall. So as an auditor of the company, we should ensure that we have checked about the regional director permission. If they have withdrawn money from that account, and also whether they have been already they say a temporary withdrawal, it means that you have to make it good later. So whether these things have been done or not, please ensure the checking. Next. NIDHI shall not provide loans only to its members. See, so the point is that NIDHI cannot provide loans to anybody else. NIDHI can provide loans only to its members. That is rule 15. Very simple. I have taken that. It's a little more reading is there. You can read it later. But to say in nutshell, NIDHI can provide loans only to its members. Next. Yeah, see, this is what is the income of NIDHI companies. The interest charge shall not exceed 7.5% above the rate of interest offered on deposits. So whatever interest that you offer on the deposits by the companies, we have seen to what extent you can pay interest. To what extent you can pay interest on deposits, we have seen in the earlier slides. So whatever interest we may be paying to the deposit holders, interest charged on the loans given to the same members or other members, it can be up to 7.5%. This is probably your spread. 7.5% above the rate of interest offered, the highest interest. It is not that lowest interest. You can see this does not mean that you have to pay the same interest, but within the permitted limits, whatever may be the highest interest you are paying to the deposit holders, on that you can have up to 7.5% margin and charge the members whom you have given the loans on the loans that you have given to these members. Next. Rules relating to directors. This is another important thing that we need to go deep into, but I have not taken in detail. I would like to share with you certain things. Director shall be a member of NIDHI. This is a very important thing. You are a member of NIDHI. Unless you are a member, you cannot become a director. In case of a public limited company or in case of a private limited company, is it necessary? Is it necessary for a person to be a member of the company? The answer is no. Can a public limited company have? Public limited companies may, in those companies, can in public limited companies, can all the directors be non-members? सब लोग हो सकते हैं क्या? किसी के पास एक शेयर भी नहीं है, that they are member, they are directors of the company. In the case of public limited company or private limited company, there can be a company where all the directors, किसी के पास एक शेयर भी नहीं है, non-members. But in case of NIDHI company, you must have at least one share. That means you are a member of the NIDHI company, then only you can become director. So from this, what is that we are getting? If you think in terms of section 149, 149(4), subsection 4, 149, subsection 6, these kinds of independent director provisions, if you recall, that that a director who has got the shareholding as prescribed in the Companies Act, that you cannot be an independent director. So independent director concept is not there in the case of Nidhi companies, because you must be shareholder. But shareholding, up to some extent, those details I'm not going into that. But the point is that whenever you think in terms of all the provisions applicable, please read that, whether it is applicable or not. I also have to read that, whether independent director provision is applicable. But you are a member of the Nidhi company. If you are a member of the Nidhi company, since it is a small company, you have interest to that extent. So subject to these kinds of things, read the applicability of those sections. So now, whenever you think in terms of that, for a consecutive period of 10 years, see in any company, public company, for example, a public company, what are the provisions of directors? On directors, kya provisions hai? The provisions are that, a director can be an additional director where he will be retiring in the next AGM. The moment starts that he ceases to be a director, additional director. Casual director, he holds up to the original time of the original director. But in case of any other director, if you recall that 2/3 and 1/3 calculation, though if you think in terms of that, directors are the director shall retire not less than, unless articles of association provides otherwise. I am trying to take you to that directors provisions in the normal companies, public limited companies, where directors, unless articles provide otherwise, not less than 2/3 of the directors shall be liable to retire by rotation. Usme 2/3 में 1/3 तो retire करना है every year. So like that, 2/3 and 1/3 calculations, if you do that, it may not be 10 years. The gap is very small. A director can be there for life in the company. Now, if you read the provisions, a director can be there for life in a public limited company if he falls within that exempted 1/3 director, unless articles provide otherwise. So now, can a person be director in a Nidhi company where he is a member? No, he has to be director only for 10 years at the most, consecutive period of 10 years. Then you can resign and you will cease to be after 10 years. Then you can have a cooling period of 2 years. Give gap after give gap of 2 years after 10 years, and then you can come back. Then again consecutively you can be there for 10 years. So this is the provision which is different from that of other public limited company directors position. Then 152(4), if you recall, go back, no? Yeah, this is actually this fourth line is very, very important. Section 152(4). What is section 152(4)? Section 152(4), if I remember correct, that is regarding the DIN. Mamata Binani madam will correct if I am wrong. I think that is regarding the DIN. So DIN is essential for any person to become a director. Same thing is required for the purpose of Nidhi companies directors also. Then not only that, if I remember another point, 152(4), subsection 4 of section 152, you have to have the DIN, number one. Number two, you have to give a statement to the company. You means who? When you are being proposed as a director to the company, aapko dena padega. See, you have to give a declaration that all the provisions of Companies Act have been complied with. So if I am proposed as a director in any company, in a public limited company, I have to give a declaration that I have DIN, and I also have to give a declaration that all the requirements of the Companies Act provisions with respect to appointment of a director are complied with from my side. So that is what is the declaration and the DIN under section 152 subsection 4. So that is required. That is required here. If there are certain sections which are exempted, go to the Nidhi company exemption sections and please read that. Then, as I told you repeatedly, I am not giving complete picture of Nidhi companies, but substantial portion of the Nidhi companies. Which section will apply, which section will not apply in the Companies Act, you have to go in detail and find out whether that particular provision section applies or not. So then section 164. What is section 164? Section 164 in the Companies Act is disqualification of director. So see that I will tell you. See that for example, if the company has not filed the balance sheets, section 164 subsection 2. if your company has not filed the balance sheets and the annual return, and that non-compliance with respect to dividends and debentures, you will be disqualified. And you will not only be disqualified, you are disqualified to hold a position of director in other companies for a period of 5 years. So these sections and provisions will apply to NIDHI companies also. That is what is the meaning of this section. This sentence, the fourth sentence in this slide. Please read in detail later. Next. Dividend. This is another very important provision in the context of NIDHI companies. You see, in case of a company, public limited company, example, can you pay dividend any amount that you want? The answer is yes. As it is, you comply with the provisions of the Companies Act, and then recommended by the board of directors and approved by the members in the AGM, or interim dividend you can pay as per the rules. But the point is that, can you pay dividend any amount to the members of your NIDHI company? You can do it, provided you take the permission from the regional director. Once he approves, once the regional director approves, you can pay beyond 25%, up to 25%. You are entitled as per your own decisions of your own NIDHI company. Then transfer of equal amount to reserves. Second condition is that whenever you declare any dividend in the NIDHI company, you need to transfer an equal amount of whatever dividend you have declared to the reserves. There has been no default in repayment of deposits and interest received. This is again, if there is, this is also to ensure financial strength of the company, soundness of the company. A NIDHI company, if it, if it has any default, if the NIDHI company has defaulted in paying interest or returning of the deposits that they have taken from the members, then they cannot declare dividend. Then it has complied with all the rules applicable to NIDHI. So all the rules we have discussed, and we are discussing almost that lot of rules we are discussing. But whatever may be the rules that there are, all the rules must be complied. Only when you are compliant of all the rules and provisions of NIDHI companies, you can declare dividend. Next. Auditors. This is a very important provision for us. No NIDHI shall appoint or reappoint an individual as an auditor for more than one term of 5 consecutive years. This we are aware of that, like it is in the other cases. As an individual auditor, I can be appointed for 5 years. Then no NIDHI shall appoint or reappoint an audit firm as auditor for more than 2 terms of 5 consecutive years. This also we have seen that in, like it is in the other case, that in the case of firm it is 5 plus 5. In the case of an individual, it is only 5. Then cooling period of 2 years. Here the cooling period provided after 5 years, or 5 plus 5 as the case may be. Cooling period provided for NIDHI companies 2 years. Then you can come back as an auditor. Next. Prudential norms. As I was mentioning to you, there are beautiful prudential norms in section that rule 20. Rule 20 prescribes a lot of prudential norms, and I don't think that we have that much time to go through in detail now, but some of the things I have already mentioned to you, so you can go through them and read it later. Every NIDHI shall adhere to the prudential norms for revenue recognition and classification of assets in respect of mortgage loans or jewel loans. This is a beautiful thing, that there are certain stages are given, 20%, 10%, so on and so forth. So these prudential norms are to be complied with every NIDHI company. Then filing of half-yearly return. Okay, half-yearly return in NDH3, the form is prescribed. You have to file as a NIDHI company half-yearly return within 30 days of the completion of that half year, and fees also is prescribed, and it must be duly certified. Okay, then who will certify this return? Half-yearly return, NDH3, who will certify? A company secretary can certify, a chartered accountant can certify, a cost accountant can certify. They are all of them are in the practice, not as they qualified, but they are in the not only qualified, but they are in practice. So the point is that NDH3, when you are filing the half-yearly return, so you need to go through the return also, NDH3. and you will find a lot of things in that. So as a professional, be very clear when you are filing these returns, when you are certifying these returns, you need to be very clear about that, because these are all finance companies. Gullible investors are there sometimes. So you need to be very careful in certifying the returns, but this is a practice area for us, but we can be careful and file them. NDH 3 with the prescribed fees, okay. Then within 30 days of conclusion of the half year, that is also okay. Certified by company secretary or chartered accountant or cost accountant in practice, fine. Next. Yes, there is another important thing here. The auditor of the company shall furnish the certificate every year to the effect that the company has complied with all the provisions contained in the rules, and such certificate shall be annexed to the audit report, and in case of non-compliance, he shall specifically state the rules which have not been complied with. Please remember, my dear friends, this is a very, very important certificate, and you know that as we have seen in case of pre-certification. See, I think a lot of company secretaries are doing pre-certification. Chartered accountants and cost accountants are also doing pre-certification of that returns to be filed with the registrar of companies. See, if there is any default, if there is any non-compliance, and you certify and file the the pre-certificated return, and if you are a chartered accountant or cost accountant, then what happens? Naturally, you will be defaulting, and if you default, there are strict provisions. If something goes wrong with pre-certification and non-compliance are there, wrongly filed, wrongly pre-certified by a professional CS, CMA or CS, then the consequences will be a little severe to the extent I understand. Then you keep in mind the certificate also must be very clearly that thoroughly checked, and only after that you should certify. And then these are all the rules, regulations. These are all small companies, but keep in mind these are all finance companies where small shareholders have incorporated their invested their money. So be careful and check. But only thing is that you need to ensure, you need to have a checklist, maybe standards if we have the comply with those standards, and then verify and then give the certificate, and it can be filed. I'll just read once and then we'll close on this slide. The auditor of the company shall furnish a certificate every year. Every year you have to do that. And then who has to do it? Auditor of the company. Please remember, auditor of the company, very clear. Not every professional. Auditor of the company only will have to give that. To the effect that company has complied with all the provisions contained in the rules, and such certificate shall be annexed to the audit report. And in case of non-compliance, as an auditor, you have to mention where things have not been complied, which provisions, which rules have not been complied, give the details. That's all. That's it about this slide. Next. Power to enforce compliance. The registrar of companies may call for such information or returns, and may engage chartered accountants, company secretaries in practice, cost accountants, or any form thereof for assistance. So the point is that ultimately the NIDHI companies, as our regional director was mentioning, is taking that is under the complete surveillance of the central government, Ministry of Corporate Affairs, and then they are trying to sensitize all the concerned people on the compliance and provisions of the NIDHI companies. So now registrar of companies, if he wants to ensure the compliance, if he wants to engage, he can engage CA, CMA or CS to find out what are not complied, take their help, and then ultimately ensure the compliance. This is the rule 23, which speaks about power to enforce compliance. So registrar of companies has got power to enforce compliance, but in enforcing such compliances, registrar of companies is empowered under the rules to take the assistance and help of CS, CMA and CS. The central government may appoint a special officer. Beyond that, if the central government wants to appoint a special officer to give more focus, then central government also is empowered under these rules to make a special officer to attend to these kinds of issues. Next. Rule 23A, compliance with the Rule 3A by certain NIDHIs. I'll just read that. There is nothing much in that. we have already read the things that are mentioned here. There is some amendment in the 2019, so I thought that I should read this with you for information. If you don't understand, you can ask me. Every company referred to in clause B of rule 2 and every NIDHI incorporated under the act before the commencement of NIDHI amendment rules 2019 shall also get itself declared as such in accordance with the rule 3A within a period of 1 year from the date of its incorporation, or within a period of 9 months from the date of commencement of NIDHI amendment rules 2019, whichever is later, provided that in case of a company does not comply with the requirements of this rule, it shall not be allowed to file form number SH7 and form number PAS3. These we have seen already. You see, in nutshell, if you want to understand, there are some companies which are NIDHI companies which might have applied for the notification by the declaration by the central government, but that is in the process. But some companies are not yet applied for. Those companies under the Companies Act 1956 also will have to ensure the compliance. And then for that purpose, a time limit is given that is prescribed in this rule 23A and as per the rules amended in 2019. So if you don't comply with that, naturally, we also have discussed that if you have not complied with these kinds of rules, this particular rule 23A, then you cannot file SH7 and the PAS3. Done. Next. Rule 23B. Companies declared as NIDHIs under previous company law to file NDH4. This is also regarding the companies, the previous law, 1956 NIDHI companies rules and all. 620A or something I have mentioned to you earlier. No, the same thing. Every company referred to in clause A of rule 2 shall file form NDH4 along with fees as per the company's registration offices and rules 2014 for updating its status. You have to update the status if you are registered, if you are a company, NIDHI company registered earlier. Otherwise, it cannot file form number SH7 and then PAS3. The same kind of things. The previous slide and this slide combined together. मिला के आप पढ़ लीजिए, आपको समझ में आ जाएंगे. Next, I think this is the last slide. Yes, rule 24. There are 24 rules under the 2014 rules of NIDHI companies, and only one section 406. These are all very small things. I think I have been able to give you complete knowledge to the extent possible within these 2 hours. And I'm quoting the last one. If a company penalty for non-compliance as a whole, entire NIDHI companies and rules, if they don't do it, what happens? Because it is under rule 24, this is non-compliance of the rules. So if a company failing under rule 2, contravention of any of the provisions of the rules prescribed herein, the company and every officer of the company who is in default shall be punishable with fine which may extend to 5,000 rupees, and where the contravention is a continuing one, with a further fine which may extend to 500 rupees for every day after the first, during which the contravention continues. And I am sure that this provision will not be applicable wherever all of us, the chartered accountants, company secretaries or cost accountants, we are employed. Wherever we produce service, we produce excellent services, and then there won't be any non-compliance. I think I am done with. Thank you very much. So I would like to also, I would like to close by only one thing. As Swami Vivekananda said, can I take one more minute?
Yes, sure, sir.
Yeah, I see that Swami Vivekananda said, he said that bring light to the educated. He said, he said that bring light to the uneducated. Bring light to the uneducated. Next sentence he says is Swami Vivekananda, because it is happening in Calcutta. Without quoting Swamiji, I think I will not be doing justice, where I am a devotee in the Ramakrishna Math. So now whenever you think in terms of that, what did Swamiji said? It is relevant to our NIDHI company's discussion. Bring light to the uneducated. And next sentence, bring more light to the educated. Because of the vanities of the world that we are in, he says bring light to the uneducated, but bring more light to the educated. because any of the that up and down Ponzi schemes, all these kinds of things come mostly from the educated people, and the things that they are not supposed to do, they do it, which they are not supposed to do it, they do it, and which they do, which they are not supposed to do it, they do it. Whatever it is, see, the thing is that bring light to all people. That light will help us to ensure the compliance, and there won't be any fear of any Ponzi companies or the failures of NIDHI companies. And then we as professionals, we are conscious to our own consciousness to ensure the compliance and to ultimately do best for the society while we flourish as professionals. Thank you very much, Mamata ji, and also the president, vice president, all of you, for giving me the great opportunity. My regards to the regional director. All the best to you all.
Thank you, sir.
Thank you very much, sir. Over to Vivek.
Thank you, sir. We are grateful that Dr. PVS Jagan Mohan Rao ji firstly accepted this session, and he took to the 24 steps in the words of 24 rules for a NIDHI company. And what happens, people get ignorant of law, and we professionals should not be ignorant of any law. And this session will enlighten all our delegates to get to do away with the ignorance about the NIDHI companies and be a bit aware of the compliance, whether it can take deposit, debenture, preference share, public company, private company, NIDHI limited. The basics should be there, and the basics were detailed, were discussed in detail by sir. And I would like to say our delegates that we will have sir's presentation with due permission of sir uploaded on our website so that people can refer in future. And formally, I would say, respected Sri Dr. PVS Jagan Mohan Rao ji, our most valued invited guest, and all the delegates who have joined this Zoom meeting. It's my privilege to have been asked to propose a vote of thanks on this occasion. Sir, I, Vivek Agarwal, the Senior VP of ACA, on behalf of ACA and on my own behalf, send a very hearty vote of thanks to you from bottom of our heart. We are thankful to Rao sir for sharing his thoughts, detailed insight, and experience on areas of NIDHI company. Sir made a detailed presentation and had a 360-degree information about the NIDHI company, discussing in detail the 24 rules in regard to NIDHI company. Sir, you inspire us as a professional as well, because along with the professional knowledge, you have written books on Bhagavad Gita. Your knowledge of Sanskrit, it inspires youngsters and we all that there is no end to passion. And along with the professional knowledge, we should also have some time for our passion, which you have taken forward in way of the writing of the books and your knowledge of Sanskrit. Thank you once again, sir, for accepting this invitation. And we are also thankful to Mamta ji and Sumit ji for making this evening possible. Thanks a lot, sir. With folded hands, we thank you on behalf of ACAE. Because as said in Sanskrit, folding hands bless us and enlighten and helps us to get more enlightenment with seniors like you, sir. Thanks a lot, sir. Thank you from bottom of our heart.
E momento.
Thank you. Thank you very much, Vivek ji. Thank you very much, Mr. Vivek Agarwal.
And I would like to share the e-memento as well for sir, because in this digital world, we are trying to be digital. And sir, you will send this across to you. You can get it laminated and post it in your office, and you can keep in your office. Thanks a lot, sir, for joining us.
Thank you very much. All the best to you. And then I'm very happy that we have been able to discuss something on the NIDHI companies. Hope I have been able to share some of the information which may be useful to you in the course of time. And whatever punya I have got from out of these deliberations today, I would like to extend to the welfare of the whole universe, because the whole universe is suffering with COVID now. So my whatever little a small bit of drop of punya I got, I would like to request the Almighty to take it to the welfare of the whole universe. And Calcutta is a special place because I have done my CS there, I have done my CA articles there, I have done my CMA there, I have worked there also. So I am happy to